The reading I gave you, the Bosley versus Andrews. Okay. All right. So if you read the case, what court is the case in? I'm reading questions on page 20. What's the name of the court that decided this case? Pennsylvania. Okay, good. Is it more likely that the plaintiff had an automatic right to appeal or requested leave to appeal, which is certiorari? If you read the manuscript that I put on Blackboard, you should have read about this. You must have read about this. Okay, what is certiorari? What is leave to appeal? What is leave? Leave, anyone? Have you heard of leave of absence? Okay, what is leave of absence? Permission to be absent. So leave means permission. So leave to appeal means permission to appeal. So this is the Supreme Court. Do you think there was automatic right to appeal or leave to appeal? How about the Korean Supreme Court? Do you have an automatic right to have the Supreme Court hear your appeal? Yes? No? Or something in between? You have a right to appeal, but the Supreme Court has a power not to hear it. So it doesn't say it is permission to appeal, but in our practical sense, it is a permission to appeal. So unless the Supreme Court grants you certain right, you don't have right to appeal. All the Supreme Courts in all the state Supreme Courts in the U.S., I didn't check, but probably have this system of leave to appeal because it gets so many cases. Each of the state Supreme Court gets so many cases from below. All right, is this a federal court or a state court? It's kind of a dumb question because I already included in the answer in my previous talk, in my previous questions. A state court. Okay. All right, next question. The opinion states the Superior Court sustained the entry of a non-suit. How many courts has the case already been heard in? How do you know? Superior Court sustained the entry of a non-suit. What is a non-suit? The Superior Court sustained the entry of a non-suit. What happened? I mean, why are the parties in this courtroom? What happened? Anyone? Usually you can answer by reading a passage in the case. What happened what made them come to the courtroom? Anyone? What happened before this case so that they came to the courtroom? You can just read the passage. Any volunteer? Okay, we'll take turns. Jiyoung, can you read me the passage?
The answer of the question?
Yes. Why did they come to this courtroom? I mean, not to this particular court, but why did they start this fight?
Because the wife of the plaintiff had heart disability due to cattle straying around the farm.
Due to a stray cattle. And what's the relationship between the cattle and the defendant?
Defendant owned the cattle.
Okay, good. And what happened?
Cattle came to the plaintiff's farm and they injured their crops.
Okay.
Mental damage
To the plaintiff. All right, good. So anyway, but the Superior Court sustained the entry of a non-suit. That means there is no lawsuit here, right? So it's one of those rulings. In the last class, I divided the trial. I divided the trial into, from the trial process, I picked out the moments when the judge makes legal decisions, right? And non-suit means there is no suit here, okay? Which means even if what plaintiff proves, or even if plaintiff is successful in proving what it claims to prove, there is no reason for lawsuit. What does it sound like among the procedural steps that, among the procedural moments that the judge disposes of, which one sounds most like non-suit? I told you about dismissal, right? I told you about ruling on motion to dismiss. I told you about ruling on motion to compel discovery. And I told you about summary judgment. And I told you about judgment notwithstanding verdict. right? One thing that I missed was motion in limine. Repeat after me, motion in limine. So, motion for J, N, or V. And here there is a jury instruction. And here is a summary judgment. No, before we go there, yes, there is summary judgment. And there is a motion to compel discovery. And motion to dismiss. Here I missed something. Right here, there is a motion for directed verdict. So these are all the procedural moments that the judge intervenes to dispose of the case or to influence the case with his interpretation of the law. All right? So this is when what the plaintiff claims to prove does not amount to any legal merit. Okay? So even if plaintiff proves something, defendant says, so what? Right? So this is also called demurrer. Because demurrer in French means so what? Motion to compel discovery is when you try to have the other party produce important evidence, not at trial, but to you, right? That's motion to compel discovery, because that's what discovery is. Discovering what the other side, what evidence the other side has. Here, depending on the judge's interpretation of the law, some of the evidence sought for to be discovered, or some of the information, some of the evidence to be sought to be discovered, may or may not be relevant. If it's irrelevant, the judge will say the motion to compel discovery is not granted, right? It's denied, right? Summary judgment is after the discovery, right? After discovery, if the judge believes, based upon the evidence, only one side can win, because a reasonable jury will never find for the other side, then the judge will stop the case right there with his version of the fact. Motion in limine is now you are in trial. Okay? Now the fact-finding process has begun, and if some of the evidence, if a judge believes some of the, well, motion in limine is when one party wants the other party not to submit something in evidence. So if a party wants to keep out certain evidence, that party files motion in limine. What's motion in limine? Well, because it limit what evidence can come in. So this is different from motion to compel discovery. Motion to compel discovery is compares the submission of the evidence to the parties, but this one concerns submission of evidence to the fact finder. Who is the fact finder at a trial, usually? jury. Yes, good. So on motion in limine, the judge decides not just whether evidence is relevant, but also whether the evidence is too unfair to be seen by the jury. The term of the art is prejudicial. Prejudicial. 그러니까 편견을 생성하는 성향이 있는 그런 증거면 역시 이제 배제하는 판단 내리는데 even here his interpretation of the law can affect whether to grant the motion or not. If certain evidence is not very relevant, okay. Again, the term is probative. Repeat after me. Probative. prove가 이제 뭐 조사한다는 뜻이죠. prove. probative. 조사하는 데 도움이 된다 이런 뜻이. 그래서 이제 relevant는 그냥 뭐 관련이 있냐 없냐라면 probative는 조사에 직접적으로 도움이 된다는 거라서 훨씬 더 좀 강한 의미를 가지고 있죠. 그래서 so the judge decides whether certain evidence is probative or not. It's one of the things that the judge thinks about in deciding whether to keep out certain evidence or not. And then during the trial, plaintiff presents their evidence, defendants present their evidence. Now they're about to grant a verdict, right? Now the jury is about to grant a verdict. Now, after looking at the discovered evidence, I told you that after looking at the discovered evidence, the judge can just rules the case in favor of either side instead of sending it to the jury, right? Same thing. After listening both sides, okay, after listening both sides' testimonies, the judge, if the judge believes that a reasonable jury will find only in favor of one side as opposed to the other, also the judge can direct a verdict. That's why it's called motion for directed verdict. So one party can, ask the judge, Your Honor, based upon the testimony so far, no reasonable party will find in favor of the other side. Please direct your verdict right now instead of have the jury decide on this case. That's direct verdict. And if the judge agrees with the moving party, the party making the motion, then the judge will grant directed verdict. If the judge doesn't want to do that, then judge has to give a lecture to the jury, right? Letting the jury know what law to apply to the facts that they find based upon the testimonies they've heard during the trial. And we call that jury instruction. And here, the judge really tries to teach the jurors the substance of the law that's applicable to the case. So, for instance, if there is an evidence that traffic light was broken, his version, his interpretation of the law will be given there on that point of law. The point being whether a broken traffic light should be abided by or not, right? After the jury instruction, a verdict is given, right? So testimonies to jury. So here is discovery ends here. Okay. Again, if a judge believes that a verdict was given unreasonably, outside the scope of reasonableness, judge can issue a judgment notwithstanding verdict. All right, having said that, to answer the question, which one sounds like non-suit? Motion to dismiss, right? So the Superior Court sustained a motion to dismiss submitted by who? Plaintiff or defendant? Who do you think submitted motion to dismiss? Defendant. Of course, defendant, right? Now, okay, and the question is, how many courts has the case already been heard in?
Three courts, including the Supreme Court.
Including the Supreme Court. Okay. Why three?
Because the first would have been the district courts, and then go to the appeals court, maybe.
Okay.
To the Supreme Court, or
Okay. Yeah. Well, usually that will be the expectation, but here it's a case decided back in 1958. There is a very high chance that it was a two-court system where there is a trial court and then the Supreme Court, which will be the only appellate court, which will be the only appellate level at the time. Probably that's why only the Superior Court is mentioned. I am telling you this because the label Superior Court is a misnomer. Superior Court is actually the lowest court. The name Superior is given only to strengthen the look of authority. Okay? So the Superior Court in other states is also the lowest court. Yeah. So probably the answer is two. So the Superior Court and the Supreme Court. Okay, who is the plaintiff and what's the story? Why is the plaintiff in court? I already asked you that. Number 4, the state law or federal law apply in this case? Is there a specific statute relevant to the case? State law or federal law? State law. Do the judges here apply state law? Yes? How do you know that they're applying state law?
Because in the dissent, one of the arguments in the dissent is that in other states, the mental damages caused without physical damages can also be considered a damage. So I guess they.
So it's a state law. Well, another evidence is if you look at paragraph 4, it says the rule is long and well established in Pennsylvania. Right? So it is state law. Now, if you read the manuscript, what I'm about to say will be a repetition of what you read, but if federal law is applicable, can the party do something like to move the case to a federal court? Do you know? Well, the answer is already included in the question. Yes. I told you that I might not have talked about this, but the federal government came into being by carving out certain powers from state government and turning over to the federal government. Okay, so there are these 50 states, and I mean it didn't really carve out, but it allowed. Okay, so these are state governments. And the state governments allowed certain area. Okay, well, there's a better way of drawing this. So there are 50 states. Just assume that there are 50 circles here. And each of the states allowed the new federal government to exercise the power that the state government would have exercised. So putting together these powers, there came a federal government. And what powers the federal government can exercise is written, guess where? What document? The U.S. Constitution. So U.S. Constitution has a very important list of things that the federal government can do. And it's called Enumerated Powers. What does it mean, enumerated? Listed. 열거됐다는 얘기죠. So, one of the powers is allowed is raise taxes. Okay? And also raise army, navy, print money, and issue patents. The list is not exactly like this or in this order. I'm just giving you a flavor of what the list looks like. And one of them in the list, one of the items on the list is regulate commerce between states. Now, same thing with judiciary. No, because the federal government can exercise only those powers that are given by the state government, it's called limited government. Now, that the state allow the federal government to exercise these powers doesn't mean that the state itself cannot exercise those powers either. Okay? That's why state has its own military. Okay? The state can, if they want, the state raise its own tax. Okay? Sometimes it can issue its own money if it wants to. But the state government has not done that. Now, so if the state government and federal government exercise the same power, citizens in that state, which law should they follow, the federal law or state law? I'm checking on what you learned from last class. Federal law or state law?
They're in conflict.
If they are not in conflict,
They're not in conflict. They can keep both.
they can keep both? They have to keep both. Yeah. They have to abide by both laws. Just like as you are a student of Korea University, so you have to follow Korea University rule. But because you are also living in Korea, you have to follow the law of Korea. And because you live in Seoul, you also have to follow Seoul City Ordinance. There's nothing very special about the federal system. If you are part of several governments, you have to comply with the powers of all those several governments that you are a subject of. But the only other rule that you need to know, because of the system being federal, is that if there's a conflict, the federal system prevails. Now, same thing with the court. Okay? Same thing with the court. The court can make decisions only in limited jurisdiction. Repeat after me. Limited jurisdiction. So, one is when federal law question is raised, and when there is a diversity of parties. Meaning if the parties come from more than one state. This sounds fair, right? If a New York resident fights with a California resident, it will be unfair, or it will sound unfair to have a New York court or California court decide the case, right? Yes, you can have a third state decide the case, but then again, the third state will not have any concern with the disputes of other state residents. So it's quite, it's quite understandable that disputes between parties from different states are given to the federal court. Here, federal law is not applied, and the type of the case that happened, somebody's ball running into a neighbor. Doesn't sound like much diversity, right? Unless the bull ran over the state border. So this is typically a state law case. Good. Now, when a case comes in, as a judge, what do you have to do? The first thing you do, We did the exercise in the last class. So when a new case comes in, what do?
You have to look at the previous cases.
Yes, you have to find relevant cases. Does the Supreme Court do that? Yes. And what are those cases? Can people tell me what those cases are? Yes, Copeland versus Legit. And what happened there?
Plaintiff claimed damages, but the court denied recovery because it didn't accompany physical damages.
Okay, what happened there? What happened to the plaintiff in Copeland?
When she was reading her suit, the presence of centipede in the spoon
Yep.
made her sick.
Okay. Probably Legit is some sort of a restaurant, and she was eating there, and a centipede. Okay, centipede appeared. How about the second case? What happened there?
Like the street in the city was like coupled down.
Right, the street caved in. 요즘 뭐라고 부르더라? 아? 뭐라고 부른다? 싱크홀. 맞아, 싱크홀이라고 그러죠. 네. Okay. And plaintiff suffered severe shock to his nervous system, which was diagnosed as an anxiety neurosis. And the court said, well, it has been well established that in the absence of physical injury or physical impact, mental or emotional distress is not the subject of legal redress. However, whereas here a plaintiff sustains bodily injuries, even though trivial or minor in character, which are accompanied by fright or mental suffering directly traceable to the prior in which defendant's negligence placed the plaintiff, then mental suffering is a legitimate element of damages. Okay, so was the plaintiff, was the victim of a cave-in, was he given damages or not for his mental shock? Probably given. Okay, all right. Now, which one is compelling precedent for you? Between Copeland and Potier, I told you we did the exercise of like looking at two cases, two traffic court, two speeding ticket cases, and then deciding what to do with them, deciding a new case based on the two old cases. What's your decision and what will be your compelling precedent? Well, to the Supreme Court, what does the Supreme Court find as compelling precedent, do you think? and base its decision on. Coupling, right? Coupling is compelling precedent. How about Potier? In Potier, recovery for the mental shock was granted. Okay? Can the plaintiff in this case argue that, we should follow Potier because, centipede swimming around, it's not, there is nothing physical there, it's just visual. But in this case, there was actual boar running after you. It's only by luck that you are not touched. When a sinkhole causes caving in of the surface that you are standing on, it's only luck that you are injured or not injured. The case is more like Potier, our case, right? Our case of being chased by the boar is more like Potier than coupling. Let's say plaintiff made the argument, and what can the Supreme Court say to that argument? That because of the heavy physical nature of this case, coupling is not really compelling precedent. It is Potier that we should follow. If the plaintiff makes those arguments, what would the Supreme Court justices have said to that argument? Anyone?
Whether one has bodily injuries or not is also standard.
Yep. If you look at paragraph 7, it's all in there. What the court would have said to that argument is all in there. Plaintiff cites number of decisions this court to support her claim, but fails to realize that in those cases where recovery was allowed for nervous shock, the nervous shock was accompanied by physical injuries. Okay. Now, that is actually the end of the case. So there, the Supreme Court distinguished Potier and other cases where recovery was allowed. 그래서 recovery는 이제 보상받는 거를 recovery라고 하죠. Now, but there's one more paragraph, paragraph 8. What's that paragraph doing there? Right? The case could have been just decided right there on paragraph 7, but the court spends one more paragraph. What are they doing? Well, they are giving additional reason.
They're saying that we can't actually prove whether those mental damages are caused by the actions of the defendant. So if this res is an issue, then we'll have to spend more time on defining whether it is actually from that point, or whether it actually happened or not, if they can't believe that.
Right. When there is no physical contact, it will be difficult to prove whether the frightening event actually took place. So if you look at paragraph 8, like say 8th line, such an event, if compensable, such an event means a frightening event without physical contact. Such an event, if compensable, may cause normal people, as well as nervous persons and persons who are mentally disturbed or mentally ill, to honestly believe the sudden and unexpected event caused them fright or nervous shock or nervous tension with subsequent emotional distress. In most cases, it would be impossible for medical science to prove that these subjective symptoms could not possibly have resulted from or been aggravated or precipitated by fraud or nervous shock or nervous tension or emotional disturbance or distress, blah, blah, blah. For every wholly genuine and deserving claim, there would likely be a tremendous number of illusory or imaginative or faked ones. Okay? So we call this a policy reasoning. Okay? Usually, the court needs not engage if the court is truthful, faithful to stare decisis. All the court needs to is find compelling precedent. It does not need to engage in policy reasoning, but the court has done that. Okay. Number 7. Question 7. If the law that governs the case is so clear, why did the plaintiff decide to go to court? What do you think? Why do you think that the plaintiff in this case, the plaintiff must have been aware of a case like Copeland?
It says in paragraph 7 that the plaintiff was actually asking them to review and change their stance because other states are doing the same thing.
Yes. The last clause says, the courts of many other states and the restatement allow recovery for shock and emotional disturbances that has been no physical injury or physical impact. Probably the plaintiff was encouraged by different rules in other states. What is restatement? It's all in the manuscript for the first lecture, but sources of law. What is source of law? Well, probably the government, right? From the legislative, what do you get? From the legislative branch, what source of law do you get? Statutes, right? Statutes. 자, 스태츄가 아니에요. T가 하나 더 있습니다. 스태츄는 그냥 동상이라는 얘기고, statut은 재정법, 그러니까 입법된 법. 법률이죠, 법률. 우리나라로 따지면 법률. From judiciary, what do you get? You get cases. From the executive, what do you get? From the executive branch, so this is from legislative, this is from judiciary. So from the executive, what do you get? Nothing, because administrative, what you get is regulation. But regulation, 그러니까 우리로 따지면 0이죠, 0. But regulation is only supposed to but regulation is not made by people's representatives. Okay? And regulation is supposed to abide by what? Statutes. Right? Regulation carries out, regulation enforces the statute. That's why in Korea regulation is called 뭐라고 불러요? 시행령이라고 그래요. 시행령. 그래서 번역할 때도 enforcement decree라고 쓰죠. 시행을 하는데 대통령 이름을 쓰면은 제일 권위가 있을 것 같아서 다 대통령령으로 만들죠. 뭐 국무총리령, 부령 전부 다 영어로 따지면 다 그냥 regulation. But regulation is not considered primary source of law. Primary source of law is statute and cases. Everything else is enforcement or interpretation of the primary sources. So we call that secondary sources of law. Secondary. 조례는 뭐라고 부르는지 알아요? 조례? 지자체 조례? Ordinance. Secondary sources. What are secondary sources of law? 논문들, 또 treatises. 논문은 이제 law review articles, and then treatises. treaty가 아니에요. 여기 s가 빠지면 안 돼요. treaty는 협정이고 treatises 이거는 뭐라고 이름을 붙이기가 그런데 여러분들 쓰는 한국법에서 쓰는 이런 것들이 다 미국에서는 treatises. So these are secondary sources of law. That's why American law students don't study treatises. They study primary sources of law, which are cases. That's why they read case books, not treatises. Okay. Now, one more secondary source is restatement. Repeat after me, restatement. Why is it called restatement? Because it states again what the cases have said. So restatement goes into analysis of all the cases and extract generalization, right? So like one restatement about speeding law will look at like many cases and extract a principle that the rainier the weather is, the wetter the surfaces are, the more dangerous the speed is. Those principles are what are stated in the restatement. And same goes for, and so there is a restatement for torts, there's a restatement for contracts, there's a restatement for properties, there's a restatement for everything else. It is analysis of cases in a certain field of law. So here, that the restatement allows recovery for mental shock is very encouraging, must have been very encouraging for the plaintiff's lawyer. That's why, despite the strong precedent in Pennsylvania, plaintiff decided to file this lawsuit. Okay. All right. Dissenters. How many dissenters are there? Can you count? Yes? two, Justice Cohen and Justice Musmano. And Musmano what objections does Justice Musmano have to the majority opinion?
The majority opinion is exaggerating in that they will not be able to prove which one is fake or not.
Okay.
But the court itself is sufficiently efficient enough to prove which one is fake and which one is
Okay. Okay. How about, so if you read paragraph 13 and 14, Justice Musmano says, look upon a raindrop and visualize an inundation. 그러니까 비 한 방울 온다고 홍수 났다고 하는 거나 마찬가지다. 이제 이런 얘기를 하는 거죠. Alright. But this is the precedent, and you are a judge in a court system that abides by stare decisis. What do you have to do? You are Justice Musmano. I mean, is Justice Musmano trying to violate stare decisis? What is he saying?
He's saying that not every single president has a binding power.
Force. Okay.
The president should at least be logical and in order up until the current point that it can stand as a binding point until now.
Good. Good. In doing so, he makes a kind of visual, poignant comparison to make his argument that the precedent is illogical. Can someone tell me what that is? If you look at the last sentence of paragraph 15, he says, it is difficult to understand why this court can allow damage for mental and nervous disability if incurred at the same time that a finger is bruised, but will deny recovery if there is no finger bruised, right? And he's saying that this precedent is precedent only because it's old and should be abandoned. Okay. And in paragraph 16, he says, I shall continue to dissent from it until the cows come home. Okay, that's a pretty strong statement of his position against the president. All right, question number 10. What are all courts in Pennsylvania bound by the decision? Are the lower courts in Michigan? Are all courts in Pennsylvania bound by the decision? The answer is, you want to say yes. Okay. Now, if the answer is no, why do you think the answer will be no? Because there are federal courts in state of Pennsylvania as well. And federal courts have their own interpretations. But this is a Pennsylvania law though, right? I mean, on Pennsylvania law, shouldn't the Pennsylvania State Supreme Court should have the final say? Well, and another thing you should think about is when does the federal court interpret Pennsylvania law? When should, I talked about how federal court is not bound by the Pennsylvania Supreme Court's interpretation of Pennsylvania law. But when would a federal court in Pennsylvania find itself deciding or debating the contents of Pennsylvania state law? Or in diversity cases, okay? In federal law cases, the federal court interprets federal law, but in diversity cases, Pennsylvania law can still be applicable, but the federal law will have to decide. For instance, if Miss Bosley, in Bosley versus Angeles, if Miss Bosley was a tourist that was visiting from California, it's very likely that the case goes to federal court, but federal court will have to interpret Pennsylvania law because Pennsylvania law will be applicable in a case like this. Because, the bull running, all of that took place within Pennsylvania. It's very unlikely that the case will involve California law. How about all the lower courts in Michigan? Are they bound by this case? Nope, right? Not at all. It's just different state. So if you read the manuscript, I talked about controlling authority or mandatory authority versus optional or persuasive authority. So Bosley versus Andrews is a controlling authority and mandatory authority for Pennsylvania state courts. But it's not controlling or mandatory authority for other state courts. But you don't have to learn this, right? This is a Japanese Supreme Court case will not be controlling or mandatory on Korean court system. But it can be persuasive, right? Korean courts can take the option of following Japanese Supreme Court case, right? So a decision made by a higher court within the court structure is controlling. Anything else is not a controlling authority. As you can see, common law court system is not very much different in terms of the binding force of court cases. Even in Korea, 대법원 판례만 따르면 되죠. 네. 그 외에 판례들은 항상 뒤집힐 수 있다고 생각하고, 물론 이제 그 조직도 하에 있는 항소법원 판례가 중요할 수도 있지만 그런 경우는 매우 드물고, 그러니까 고등법원들이 막 고등법원별로 판례가 막 갈리는 경우는 이렇게 드물고, 그리고 보통 그렇게 되면 이제 대법원에서 빨리 결정을 내려주죠. 그리고 고등법원들은 이제 부 숫자가 되게 많으니까 그게 별로 그렇게 중요하지 않고, 그래서 뭐 이건 뭐 특별한 건 아니고 어느 법원 시스템이든지 그 똑같은 on the same point of law, if the same point of law has been touched upon by higher court in your jurisdiction, then you as a judge and the lower court are bound by it. It's mandatory that you follow it. Okay. Right, let's look at hypotheticals. Now you know 3 cases out of Pennsylvania on the point of law of whether recovery should be allowed for purely mental damage, right? Now you know Potier, you know Copeland, and you know Bosley, right? So let's apply those cases to the following hypotheticals. Okay, Mrs. Bosley sees a bull charging toward her. Okay, let me see. Okay. Okay, Yerim. Yes. Can you solve the first hypothetical?
She got physical suffering. It was affected directly from the attack.
It should be allowed or not allowed? Okay, all right. Shine, the second one.
I think that
Okay, can you speak louder?
I think the damages she seeks will be granted
Okay, because notice that she was not touched by the bull.
but if she can prove that by throwing herself on the ground, but if throwing herself on the ground was the only way by which she could avoid it, was presented to the court as by the broker.
Okay, good. Yang-san? Okay. The last one?
I don't think she would be able to be recovered
Mm-hmm.
because there, according to the president, there is no physical harm in this situation unless the centipede's really hard and she broke her teeth.
But she felt something crawling in her mouth. There was a physical touch. What do you think?
Physical touch and physical damage are different.
Mm-hmm.
So in this case, if there was no physical damage, I don't think it would be different.
Well, let's look at the cases. Physical impact. Physical impact. So it's physical injury. Well, it really depends on what physical impact means. I have really no idea what Pennsylvania court would have done because it's old precedent. But if you follow the policy reasoning, what do you think? Do you think it should be, if you follow the reasoning in paragraph 8, do you think that this what she suffered mentally, but from the physical touch, should be recoverable?
I think it's debatable.
Well, probably, I mean, in paragraph 8, the Supreme Court is worried about illusory claims, right? And, whether the centipede actually was in her mouth or was right outside the lips. It can give rise to illusory claims as well, unless there is some physical trace of the centipede in the mouth. I'll stop. Okay. So you did the first case from you did the first common law reading and the first Socratic discussion of a common law case, and we'll continue to do that. Now, if you look at the book, there is a vocabulary development which you can do yourself. You'll have to do it yourself because the answers are in the back. Okay? So, but please do them. Thanks to Google, if you want to read the entire case that each excerpt comes from, for instance, page 16, the first sentence says, Garcia remains good law. Its reasoning has not been repudiated and has not been challenged here. Alden versus Maine. So the sentence came from this case, Alden versus Maine. And if you just type up the case, you will get the full text of the case. Okay, maybe we should do this. We should do task 3. All right, Garcia remains good law. 좀 삐뚤게 쓰여져 있는 거는 이제 이게 판례 이름이라서 그런 거죠. Page 16. Garcia remains good law. Its reasoning has not been repudiated. It has not been challenged here. Okay, all right, that's one sense of good law. Good intentions unsupported by well-informed policies often result in bad law. Henry versus Dow Chemical. Now, the sense of good and bad in the sentence 1, is that same as sense of good and bad in sentence 2? What do you think? No. Okay. The first one is talking about whether it is a good law in the sense of supported by precedent. Okay. So the question 1, the sentence 1 is talking about a law being procedurally good. Good under the principle of stare decisis. Okay? But sentence 2 is talking about substantively good or bad. Question 3, developing good law on which people may rely, for example, mechanisms to secure credit or protect intellectual property, allows much higher levels of economic performance. Substantively good or procedurally good? Substantively good. We must acknowledge that Aguila, as well as the portion of Ball addressing Grand Rapids share time program, are no longer good. Procedurally good or substantively good? No longer good. Procedurally, right? Okay, so you can do the rest. And as far as this textbook is concerned, you can read more, and please read page 32, Acken Road, and page 52, Needleman versus Brodsky. So we'll talk about those two cases on Thursday, and today we'll spend the rest of the class talking about the general structure of tort law, because the case you just read is a tort case, okay? And you can now position what you just learned in the general structure of tort law. Okay, where is the, good. Okay, you can rest a minute while I prepare for this.